Hello, I'm Inu. The topic that we are discussing that is law of contract, and under law of contract in this video we will be discussing the discharge of contract. Discharge of contract is referred to the termination of contractual duties or dissolution of contract. A contract may be discharged in any of the following way. Firstly is discharge by frustration. Discharge of frustration. A contract may be frustrated where there exists a change in circumstances after the contract was made which is not the fault of either of the parties, which renders the contract either impossible to perform or deprives the contract. Then I will provide one example of cases to more on courier contracts to deliver a package within specified time frame. The courier accepted the risk of delivering on time, doing so by entering the contract. The courier doesn't deliver on time, the courier is in breach of contract. Frustrating the contract reverses the risk of delivering onto the customer.
Discharge by performance. When the parties to contract the fulfill of obligation arising under the contract within the time and manner prescribed, then the contract is discharged by performance. For example, Peter agreed to sell his cycle to John for an amount for Rs 1000 to be paid by John on delivery of the cycle. As soon as it delivered, John paid the promised amount. Since both the parties to the contract fulfill their obligation arising under the contract, then it is discharged by performance. Now, discharge by the performance of the contract can be by: first, actual performance; second, attempted performance. As shown in the example above, actual performance is when all the parties to a contract do what they had agreed for under the contract. On the other hand, it is possible when the promiser attempts to perform his promise. The promiser refuse to accept it. In such case, it is called attempted performance or tender.
Discharge by breach is a failure or refusal by one or both parties on the obligation imposed. A breach can occur in some ways, which is failure to fulfill with the terms of the contract. A party announces to the other party that they are no longer interested in carrying out their obligations, or delay in the performance where time is essence in the contract. This case stated where one party communicates their intention not to perform the contract. The innocent party need to not wait until the breach has occurred before bringing their claim. They may sue immediately, or they can choose to continue with the contract and wait for the breach to occur.
Discharge of remedies. Damage. Most common remedy granted by the court in cases of breach of contract where the main purpose is to enable innocent party to receive monetary compensation from responsible for the breach of contract. Type of damage. Number 1. Compensatory damage, which is damage paid to directly compensate the non-breaching party for the value of what was not done or performed, are compensatory damage. Number 2. Consequential damage. These are damage incurred by the non-breaching party without action on his part because of the breach. Conclusion. The law on damage is provided in Section 74 of the Contract Act. It provides that when a contract has been broken, the party who suffers by the breach is entitled to receive from the party who has broken the contract compensation for any loss or damage caused to him.
Rescission means the voiding of a contract not recognized as legally binding. The courts can free non-liable parties from their agreed obligation and, when possible, will effectively seek to restore them to the position they were in before the contract was signed. How rescission works? Rescission involves cancelling a contract and treating it as though it never exists by ensuring that all its effects are eliminated. To return all parties to their original state, things that were exchanged, such as money, must be returned. Example of rescission. A common practice in the insurance industry. Companies provide life, fire, auto and health cover have a right to rescind policy without court approval. For example, they can prove the application was submitted with false information. Consumers who want to fight this can then take the decision to a court.
Specific performance. Specific performance is a discretionary order granted by the courts directing a person to carry out their obligation under the contract. When specific performance are available: first, contract for disposal of land; second, contract for sale and goods; third, contract for disposal of share; fourth, contract to lend money; and lastly, contract for personal service or offering service. In this case, the shares of the bank were not available in the open market, and courts could therefore order specific performance of an agreement for the sale of the share, and in this respect the defendants had not established that the circumstance had changed.
Injunction is a legal remedy which is imposed by a court. Okay, in simple terms, an injunction means that one of the parties to a certain action must either do something or refrain from doing something. Okay, unlike specific performance, this is a court order restraining a part from breaking their contract or from committing a wrongful act and will not be awarded if damage are an adequate remedy. Okay, the type of injunction is preliminary injunction and temporary restraining order. Okay, injunction may be first prohibitory, second obligation, and third is interlocutory. Okay, did you know example in injunction is first, secure an undertaking to avoid full injunction hearings, undertaking from group of ex-employees. The group leave a vintage software company to join a Silicon Valley competitor and utilize company information. Okay, we file the undertaking with the court not to be complete for 1 year.